So we've got a major new development in the nationwide legal fight to dismantle the NFA after the $0 tax change. In one of the newest lawsuits challenging the NFA based on the same $0 tax change, the plaintiffs are already pushing for a full summary judgment win. This means that this case may get actually fast-tracked towards a ruling before some of these other pending cases. So let's break down what just happened in this critical lawsuit. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also click the like button that just tells the algorithm that you appreciate this content, and so it shares it with more people. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. And right now, for the anniversary of the United States, they're actually doing an additional promo code. So if you use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off of your family fee. So as I mentioned in the intro, this case that we're going to be talking about is part of kind of the broader wave of challenges that followed Congress reducing the NFA tax to $0 for certain items like suppressors, SBRs, SBSs, and AOWs. This came after Congress passed the One Big Beautiful Bill Act, and again, that reduced the NFA tax for those items from $200 all the way to $0. Again, that applied to all these items like SBRs and suppressors. Now, historically, the tax was the entire constitutional foundation of this law. The NFA has been upheld in the past because it was framed as an actual tax. But now that the tax has effectively been reduced to $0, the plaintiffs in many cases, including this one, argue that the law is no longer functioning as a tax at all. Instead, what remains is a system of registration, restrictions, and criminal penalties that looks simply like a standalone regulatory scheme. Now, as I mentioned, there has been a new lawsuit that was filed in a federal district court in Kentucky, and it aims to dismantle the NFA. This complaint was filed with the support of Second Amendment Foundation and FBC, and in this case, they're asking the court to declare that the NFA is unconstitutional as applied to the untaxed items and that they should enjoin its enforcement. The complaint in this lawsuit makes a very direct argument. They argue that the NFA was constitutional only because it functioned potentially as a tax. Now that Congress has eliminated that tax for most covered items, the regulatory scheme no longer rests on Congress's enumerated taxing authority. And unlike the GCA, the NFA contains no interstate commerce jurisdictional hook in its core provisions, and that is critical. The plaintiffs argue that you cannot convert a tax statute into a permanent regulatory regime once the tax now disappears. If there is no tax, then there is no constitutional basis for the NFA. But this case doesn't stop just with the taxing clause. It also makes a full Bruin Second Amendment challenge as well. The complaint argues that suppressors are in fact arms protected by the Second Amendment, that short-barreled rifles are also protected arms, that they're in common use, and that they are not dangerous and unusual items. The government itself has conceded that suppressors are protected arms in other litigation like the Peterson case. So the plaintiffs argue that there is no historical tradition supporting the NFA's comprehensive registration regime against these protected arms. And because these items are now untaxed, the government cannot rely on the taxing power and that justification anymore, and they can't just suddenly try to pull in a new justification to protect the NFA. Now, like I mentioned, this case was filed in the Eastern District of Kentucky within the Sixth Circuit's jurisdiction. That matters also very strategically because the Sixth Circuit has older precedent upholding the NFA under the Commerce Clause. But that precedent actually predates Bruin and predates the $0 tax change. So this lawsuit forces a new appellate court to confront the same constitutional question that is now being litigated in other district courts, some out in Texas and also under the Fifth Circuit's jurisdiction. And again, if there's a circuit split, if the court split on this issue, that dramatically increases the likelihood that the Supreme Court will have to get involved. Now, in this case, the plaintiffs want a declaration that the NFA's requirements for untaxed items like suppressors and SBRs exceeds Congress's enumerated powers. They also want a declaration that suppressors and SBRs and those regulations violate the Second Amendment. They also want a permanent injunction against the ATF and all federal agents in their enforcement against these items. So they are asking for a very sweeping request and a sweeping block on these NFA restrictions. Now, also the new update in this case is that the plaintiffs are now filing for a motion for summary judgment in this Kentucky challenge. They are trying to leverage the favorable jurisdiction to get a ruling on this issue as soon as possible. So normally what you would see in a traditional case, if it went to a full trial, you would see the complaint filed, the government would file its answer, the case would move towards a discovery, months or even years go by, and then maybe you would get a ruling on the merits from the court. But that's not what they're trying to do in this case. Instead, the DOJ's answer to the complaint is currently being stayed while the case moves forward directly to a summary judgment review. So what does that mean? Well, it means that the plaintiffs are telling the court that there are no real factual disputes in this case. There is purely a legal question that needs to be addressed, and that the court can decide this right here and now. And this is a deliberate move to kind of fast track this constitutional issue for review and get a ruling. So in this case, this issue is no longer just theoretical. Congress actually changed the tax. We all know that. And the litigants are now testing whether the change actually collapses the constitutional justification for the entire NFA scheme. And this new case shows that this challenge is actually spreading to other areas. You have different courts, different circuits, all challenging this NFA structure based on the $0 tax theory. And if one circuit splits from the other, the Supreme Court will eventually have to step in. So this is a major development in the fight against the NFA based on the $0 tax change. A brand new lawsuit, again, was filed in Kentucky that's dealing with the same $0 tax theory. It's dealing also with the broader Second Amendment issues. And now you also have this new area involved. And the plaintiffs are trying to move this Kentucky case towards a summary judgment decision and get this resolved as soon as possible. This all means that there's going to be added pressure on the NFA on this issue, and potentially even more pressure put eventually on the Supreme Court to have to deal with this if they don't address some of these issues in maybe a different case, a different hardware case, like some of the assault weapon bans and magazine bans. So as this case progresses and some of those other cases progress down in Texas, I will keep you guys updated. But again, this is a good development because they're trying to fast track a ruling in this case and get it up the ladder of appellate court review to again put more pressure on circuit courts and eventually the Supreme Court to address this NFA issue based on the $0 tax change. So as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.